Thank you, distinguished members of the government. My question is to the Prime Minister of the Republic of Armenia. Honorable Prime Minister, even though official Yerevan has repeatedly stated that the Republic of Armenia has no territorial claims in its constitution to any country, and despite the fact that the Constitutional Court of Armenia adopted a decision which also legally substantiates these assertions, we continue to hear from Azerbaijan in response claims that nevertheless there are territorial claims and that they expect that the Republic of Armenia should change its constitution. I would ask you to use this opportunity to once again present the position of the Republic of Armenia to our society and to the international community. Thank you. Thank you, Mrs. Julhakian, for the question. Azerbaijan's claims that the Republic of Armenia constitution contains territorial claims on Azerbaijan is based on the argument that the preface to the Constitution of Armenia contains a generic reference to Armenia's Declaration of Independence, which in turn mentions Nagorno-Karabakh. In its decision adopted on September 26, 2024, the Constitutional Court of Armenia found that the reference in the preface of the Constitution to the Independence Declaration concerns only those provisions of the Declaration which have been literally enshrined in the articles of the Constitution. In the text of the Constitution of Armenia, no provision contains direct or indirect mention of Nagorno-Karabakh. There's a clear hierarchical difference between the Constitution and the Declaration of Independence in terms of the adopting entities. The Declaration of Independence was adopted by the Supreme Council of the Armenian Soviet Socialist Republic as a state body of one of the 15 Soviet republics, whereas the Constitution was adopted by the sovereign people of the Republic of Armenia as an internationally recognized independent state. So this is the first argument. Secondly, the preface to Azerbaijan's constitution contains reference to the Constitutional Act adopted on October 18, 1991. The Constitutional Act, in turn, refers to the Declaration of Independence of the First Azerbaijani Republic, adopted on May 28, 1918. The Declaration of the First Azerbaijani Republic, in turn, notes that the First Azerbaijani Republic includes Eastern and Southern Transcaucasia. In November of 1919, the Republic of Azerbaijan presented to the Entente its administrative territorial map, according to which Azerbaijan includes the Syunik and Vayot-Zor marzes of Armenia fully, as well as parts of the Ararat, Armavir, Gegharkunik, Tavush, Lori, and Shirak marzes of Armenia. So, in total, around 60% of Armenia's current territory. Thus, with these references, it becomes obvious that Azerbaijan's constitution contains territorial claims on the Republic of Armenia. The Republic of Armenia, however, is not raising the question of changing Azerbaijan's constitution due to two reasons. Firstly, such a demand would drive into deadlock the Armenia-Azerbaijan peace process, and secondly, the agreed part of the peace agreement between Armenia and Azerbaijan contains an article which provides that the parties may not invoke their domestic legislation to justify failure of implementation of this agreement. Another article of the agreed part of the peace agreement notes that the parties recognize each other's territorial integrity, do not have territorial claims on each other, and undertake not to make such claims in the future as well. What this means is, and this is something I want to cover under the next point, under the legislation of the Republic of Armenia, after signing of the peace treaty, it must be ratified in the parliament. This is a mandatory condition. Before that, the government is obliged to send the agreement to the Constitutional Court to check its conformity with the Constitution of Armenia. If the Constitutional Court decides that the text of the peace agreement, if the Constitutional Court decides, which after the September 26th decision is highly unlikely, but still, if the Constitutional Court decides that the text of the peace agreement is not in conformity with the Constitution, the Republic of Armenia may initiate constitutional amendments, because we need to have a choice. We signed a peace treaty, and if the Constitutional Court says it is not in conformity, then it's a matter of political choice. If the Constitutional Court decides that the text of the peace agreement is in conformity with the Constitution of Armenia, it will move to ratification and will pass ratification in the Parliament of Armenia. According to that, under paragraph 3 of Article 5 of the current Constitution of Armenia, in case there's an inconsistency between ratified international treaties of Armenia and laws, the international treaty provisions shall apply. Thus, after ratification of the Armenia-Azerbaijan peace agreement in the Parliament, the agreement will have prevailing legal force over the Republic of Armenia laws and other normative legal acts, which logically concerns also, in a mirrored way, Azerbaijan. And this is the reason, among other reasons that I mentioned, why we are not raising the question of amending Azerbaijan's constitution. And according to the same logic, I think that in this context, there is no need for amending the Constitution of the Republic of Armenia. Thank you.